Hello friends, once again I welcome you all to AVISION Institute and Institute for CLAT, AILET and other law exams. So, in today's session we will be discussing about again Law of Torts, and today's topic is going to be vicarious liability, as you can see on the board. So, let us first know what is liability. So, liability is something when some wrongful act is done, in case of a tort. Just suppose a tort has been committed, okay. Just suppose a tort has been committed, and then what will happen? Who will be liable for that wrongful act? Who will be liable for that wrongful act? Just suppose the wrongful act has been committed by the defendant. A wrongful act or a violation of a legal right has been committed by the defendant. Now, the legal right of the plaintiff has been violated by the defendant. So, the defendant commits a tort. Now, whom will the liability fall to? Okay, who will be liable for this wrongful act? Now, obviously the defendant is going to be liable for this wrongful act, not anybody else. So, obviously the liability goes to the defendant. Now, as you can see on the board, what is vicarious liability? It is the exception to the natural rule. Now, vicarious liability is the exception to the natural rule. Now, what is the natural rule? Now, natural rule is that the law says that our law says that if I have done something wrong, then obviously I will be liable for that wrongful act. Okay? If I have done something wrong, I will be liable. If he has done something wrong, he will be liable. Okay? Nobody else is going to be liable for my wrongful act. Nobody else is going to be liable for my wrongful act that I have done or I have committed. Okay? So, vicarious liability is just an exception to this rule. This is the natural rule, that I am going to be liable for my wrongful act. This is the natural rule. But vicarious liability is the exception to this rule. Means it is just the opposite of this rule. Okay. So, let us see what is vicarious liability. In tort, there are more to liabilities. We will be having a separate session of that liability, that is your strict liability and absolute liability. So, we will be discussing on strict liability and absolute liability in a separate session. But today we are going to discuss about vicarious liability. So, let us read out. Liability of one person for the act done by another person. So, obviously, this is the exception. Now, what is vicarious liability? That I have done something wrong, but just suppose I am X, okay. So, X has done something wrong, but who will be liable? Y will be liable for it, for that wrongful act. So, how come this is possible? How is this possible that one is going to do the wrong and the other person is going to be liable? Okay. So, let us see the points. So, let us see the points. What is the first one? Liability of A for the act done by B. So, these are the essential requirements or ingredients of vicarious liability that should fulfill. If we want to say that this act is falling under vicarious liability, then these ingredients must be followed or must be fulfilled. Okay. First one is A, liability of A, means A is liable for B's act. Okay. So, B has done something wrong, but A is liable. Okay. Next is, there should be a certain kind of relationship between A and B. So, this is another very essential ingredient to constitute a vicarious liability. What is it? That there should be a relationship, a kind of relationship, whatever it may be, but relationship has to be there between A and B. Okay, relationship has to exist between A and B. Now, next is what? The wrongful act should be in a certain way connected with that relationship. So, the wrongful act should be connected with that relationship between A and B. So, if some wrongful act has been committed by B out of the relationship between A and B, out of the relationship between A and B, just suppose that I have a relation with, I am A and I have a relation with B, that we are employer and employee, okay? Or we can say I am the agent and he is the principal, okay? I am his principal, I am B's agent, I am B's agent, okay? So now in this case I have a relationship between B with B, I am A and I have a relationship with B, principal agent relationship. Now in this case, if I commit a wrong, if I commit a personal wrong, okay, out of this professional relationship, so I am sharing a professional relationship with B, but if I do a wrong, if I commit a wrong out of this professional relationship, just suppose that I committed a wrong in my personal relationship. So in this case, B is not going to be liable. Okay, I will be liable because it was my personal wrong. Okay, but if the wrong is related to this relationship, then only you can say that this is a vicarious liability. So what are the examples? You can see what are the examples. So vicarious liability can be of different kinds. These are the examples that you can see. Okay. Number one is liability of the principal for the tort of his agent. So what is number one? The principal is going to be liable for the act of his agent. Okay, the principal is going to be liable for the act of his agent. Okay, so what is it? There is a relationship between the principal and agent. There is a relationship between the principal and agent. Just suppose I am the principal, okay, and I am authorizing somebody, I am giving permission to somebody and I am making him my agent to do this work. Okay, so he becomes my agent, I have authorized him to do my work. Okay, now just suppose, just let me give you a small example. If I say that I have a car and I want to go to a long drive with my friend. Okay, now who is the owner of the car? I am the owner of the car, but I told my friend, I gave him a proposal that I want you to drive the car, okay, and we will go on a long drive. Now my friend becomes my agent. Now if he on the highway, if he knocks down somebody or if he commits an accident, if he faces an accident on the road, then he is not going to be liable. Okay, he will be liable obviously, but who will be primarily liable? What will be the first preference? I will be liable for my agent's wrongful act. So principal is going to be liable for the agent's wrongful act. Obviously the agent is also liable, so jointly they will be liable. Principal will also be liable, agent will also be liable, and there will be a joint liability. There will be a joint liability, which is also in tort, which is also called joint tortfeasors. Tortfeasors. Okay, let me write it here. Joint tortfeasors. Okay, so this is the term in tort. This is the term that you will be finding in law of tort. So joint tortfeasors means who are jointly liable, they are called joint tortfeasors. Okay, So this was about principal and agent relationship. Next is liability of partners of each other's tort. Okay. So what is the meaning of this one? Liability of partners for each other's tort. So just suppose that I am a partner in a partnership firm. Okay. I am one of the partners. So in a partnership firm we are 10 partners. Okay. We are 10 partners are there and we are having a partnership firm. Now just suppose I have taken bribe from other company. Okay. And I did not say this to anybody, any of my partners, but I accepted bribe. Okay. But I accepted bribe from other company, and obviously this is an illegal and unlawful act. Okay. I did not inform my partners, so I acted maliciously. It was a wrongful act done against my other partners. So I accepted bribe with an ill motive. Okay, I committed tort. Alright. Now what will happen? Not only me, but all my partners are going to be liable for my wrongful act, for my tort. So all the partners in a partnership firm are going to be liable for the wrongful act done by one partner, that is me. Okay. What is next? Liability of the master for the tort of his servant. So what does this mean? The master is going to be liable for the tort committed by the servant. So just suppose I am the master and I am having a servant. If I give the responsibility, or just say I tell my servant to bring some sugar, okay, and while bringing sugar he knocks down a person, with his motorcycle or whatever cycle, bicycle, okay, and he faced an accident and he commits a tort, okay, by negligently riding the cycle or negligently riding the motorcycle. So he was negligent, he was riding negligently and he committed a tort of negligence. Okay, due to him harm was faced by some person. Okay, some person faced physical injury, some person was injured due to the wrongful act, due to negligent riding of my servant. So I am the master. Okay, so my servant committed a tort. So do only my servant will be liable? No, I am also going to be liable for the tort committed by my servant. So I and my servant both are going to be liable for the tort committed by my servant. Okay. So these are small examples which clears the concept of vicarious liability. So you will have to remember these three examples if you want to clear the concept of vicarious liability. So this was all about vicarious liability. I guess the concept of vicarious liability is clear and it is very much essential if you are preparing for any law competitive exams or entrance exams. This vicarious liability concept is very important. Okay. So I guess you liked the session, and please don't forget to subscribe to our channel and don't forget to click the bell button to get all the notifications that are updated in our channel. Thank you.